Gentlemen, the chair recognizes the gentleman from Utah, Mr. Chaffetz, and as I do so, I want to thank him for making, as chairman of the Oversight and Government Reform Committee, this very nice hearing room available to us while the Judiciary Committee hearing room is under renovation. So, gentleman is recognized for 5 minutes with my thanks.
Well, and I appreciate the extra 5 minutes of questioning for doing so, so thank you very much. Director, thank you for your accessibility. You have been very readily available, and we do appreciate that. This investigation started because the Inspector General found classified information in a non-secure setting, and the FBI went to a law firm and found this information. They seized at least one computer and at least one thumb drive. Did you need an immunity agreement to get those?
It was not, I don't think there was immunity. In fact, I'm certain there was no immunity agreement used in connection with that.
So, did it really take the FBI a full year to figure out that Cheryl Mills and Heather Samuelson also had computers with classified information on?
No, it took us to that point in the investigation to insist that we try to get them.
Were you getting them because they had classified information or because there was some other information you wanted?
No, we thought those were the tools, as we understood it, that have been used to sort the emails. And the investigative team very much wanted to understand, if they could, whether there was an electronic tale of how that had been done. Because the big issue was, what did they delete, what did they keep?
But why did you need an immunity agreement? Why didn't they just cooperate and hand them over? The law firm did, didn't they?
Well, yes. That's a question really I can't answer. That's between a lawyer and her client and the Justice Department lawyers. For whatever reason, her lawyer thought it was in her interest to get an active production immunity agreement with the Department of Justice.
The FBI interviewed David Kendall's partner, but did not interview David Kendall. Why didn't you interview David Kendall?
I don't remember. I don't remember that decision.
Going back to this Reddit post, this is put up on July 24th of 2014. You believe this to be associated with Mr. Gambetta, correct?
Yes, I think that's right.
This is the one that Mr. Jordan put up about the need to strip out a VIP's very VIP email address and a bunch of archived email. This is he's referring to a federal record, isn't he?
I don't know exactly which records he's referring to.
How is this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
I'm sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, it depended on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit on these records.
Sure. That's why the guy wouldn't talk to us without immunity.
And so when you got immunity, what did you learn?
We learned that no one had directed him to do that, that he had done it.
You really think that he just did this by himself?
I think his account, again, I never affirmatively believe anybody except my wife, but the question is, do I have evidence to disbelieve him? And I don't. His account is credible, that he was told to do it in 2014, screwed up and didn't do it, panicked when he realized he hadn't, and then raced back in and did it after Congress asked for the records and the New York Times wrote about them. That was his SHIT moment. And that was credible. Again, I don't believe people, but we did not have evidence to disbelieve that and establish someone told him to do that. No email, no phone call, nothing. The hope was, if he had been told to do that, that would be a great piece of evidence. If we give him immunity, maybe he'll tell us, so-and-so told me to, so-and-so asked me to, and then we're working up the chain.
But he did indeed destroy federal records, and he was told at some point to do this, correct? Who told him to do that initially? When he was supposed to do it in December, and he didn't do it. Who told him to do that?
One of Secretary Clinton's staff members, I can't remember sitting here, we know that. One of her lawyers might have been Cheryl Mills. Someone on the team said, we don't need those emails anymore, get rid of the archive file.
This is what's unbelievable about this, because there's classified information, there are federal records that were indeed destroyed. And that's just the fact pattern. Let's go back to this. Here's the other thing that I draw to your attention that is new. September 15th of this year, I issued a subpoena from the Oversight and Government Reform Committee. On these Reddit posts, 4 days later, they were destroyed or taken down. They were deleted. I would hope the FBI would take that into consideration. Again, we're trying under a properly issued subpoena to get to this information. Let's go to Heather Mills real quick. How does in the 2016 interview with Cheryl Mills, she says, quote, Mills did not learn, in the interview report, the interview summary from the FBI, Mills did not learn Clinton was using a private email server until after Clinton's tenure. Back, also, you have this interview with Mr. Pagliano, who said he approached, quote, Pagliano then approached Cheryl Mills in her office and relayed a State Department employee's concerns regarding federal records retention and the use of a private server. Pagliano remembers Mills replying that former secretaries of state had done similar things, to include Colin Powell. It goes then on to a page 10, and this is what I don't understand. The FBI writes, Clinton's immediate aides, to include Mills, Abedin, Sullivan, and a redacted name, told the FBI they were unaware of the existence of a private server until after Clinton's tenure at State or when it became public knowledge. But if you look back at the email from Heather Mills, if you go back to 2010, this is to Justin Cooper, okay? Mills to Cooper, who does not, he works for Clinton's. He doesn't work for the State Department. FYI, HRC email coming back. Is server okay? Cooper writes back, you are funny. We're on the same server. She knew there was a server. When there was a problem with Hillary Rodham Clinton's emails, what did they do? She called the person who has no background in this, who's not a State Department employee, no security clearance, and then tells the FBI, well, I never knew about that. But there's direct evidence that contradicts this. How do you come to that conclusion and write that in the summary statement that she had no knowledge of this?
That's a question.
Yes.
The time of the gentleman has expired, but the director will answer the question.
I don't remember exactly sitting here. Having done many investigations myself, there's always conflicting recollections of facts, some of which are central, some of which are peripheral. I don't remember sitting here about that one.
The chair recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Director Comey, violent crime is up in this country, isn't it?
Our UCR stats we just released show a rise in homicide and other violent crime in
The
15.
violent crime, I think, was about 4%, but the homicides were up 10%. Is that correct?
Right, 10.8%.
And that's a pretty startling, concerning increase. Do you agree?
Yes, it is concerning.
Now, I don't know if you have data in 2016, but is your sense that 2016 is going to look closer to 2015, or will it be, is there any indication that the rate's going to go back down?
No, we continue to see spikes in some big cities in a way we can't quite make sense of. There's no doubt that some 15 to 30 cities are continuing to experience a spike. Whether that'll drive the whole number up, I don't know.
Now, the FBI has now assumed control of the Dahir Adan, the Minnesota stabbing terrorist investigation. Is that confirmed that that was a terrorist attack at this point?
We're still working on it. It does look like, at least in part, he was motivated by some sort of inspiration from radical Islamic groups. Which groups and how, we're not sure of yet.
But he was praising Allah, was asking at least one of the potential victims whether they were Muslim, and I know ISIS did take responsibility for it, correct?
They claim responsibility. That isn't dispositive for us, because they'll claim responsibility for any savagery they can get their name on. But we're going through his entire electronic record and history of all of his associations to try and understand that.
Now, there was a report from the House Homeland Security last year that said that Minnesota was actually the #1 source for ISIS fighters in the United States. One, do you acknowledge or do you agree that that's true? And if so, why is Minnesota churning out so many jihadists?
I don't know for sure whether that's true, but it sounds about right. We have very few ISIL fighters from the United States, even over the last 2 years. There have been a number of Somali American heritage young men who've gone to fight with al-Shabaab in Somalia and with ISIL. I suspect the reason is that's one of the few areas in the United States where we have a large concentration susceptible to that recruiting. The great thing about America is everybody's kind of dispersed. That's one of the areas where there's an immigrant Muslim community that seems to be susceptible for some reason. In small measure, again, we're talking about 8 people, I think the number is, but that's my reaction to that.
Well, what's the FBI doing to deal with the problem? You have an insular community that may make this problem more significant. So how is the FBI combating that?
Oh, in a bunch of different ways, with lots of partners, to make sure we know the folks especially the Somali American community in Minneapolis. The U.S. Attorney there has done a great job.
Have they been helpful with the FBI?
Very, because they don't want their sons or daughters involved in this craziness any more than anybody else does.
Now, with Paul Combetta, I'm just trying to figure out what happened here. He never said that he remembered anything from that March 25th phone conversation with the Clinton people. Of course, that was days before he bleach-bitted the emails. He never said he had any factual knowledge of anything that happened on that call. Is that his basic statement? So I read the 302s. He didn't really provide any information.
I can't remember for sure it being the 302. You've probably seen it more recently
Well,
than
and
I
I
have.
saw one 302 said that he pled the Fifth. Obviously, he was given immunity. Another said that there was an invocation of attorney-client privilege at one time in one of the other summaries. So I'm just trying to figure out, what happened with Combetta. Why was he not able to provide information? He had immunity. This was something that was much more fresh in his mind than previous conversations with Clinton people would have been. And yet you said he was credible. To me, feigning ignorance, that is not credible given the timeline where you have the New York Times saying that this server existed. The House immediately sends a subpoena. He has this conversation, and then lo and behold, a few days later, all the emails are bleach-bitted.
Oh, he told us that with immunity, that no one directed him to do it, instructed him to do it. We developed no evidence to contradict that. Again, we're never in the business of believing people. The question is always, what evidence do we have that establishes disbelief? We don't have any contrary evidence. His account is uncontradicted by hard facts.
Well, he's in a situation where these things are now under a subpoena, and he has conversations with people who they potentially could implicate, and then he takes this action. So I guess the question is it more reasonable to think that he just would have said, oh, you know what, I just need to all of a sudden bleach-bit this stuff without any direction at all? I just find that to be something that is difficult to square. Let me ask you this. In September, you sent a memo to your employees at the FBI basically defending the way the Bureau handled this investigation. Why'd you send that?
It was about how we were doing transparency, because there was all kinds of business about whether we were trying to hide stuff by putting it out on a Friday, and I wanted to equip our workforce with transparency about how we were doing our productions to Congress so they can answer questions from their family and friends. I want them to know we're conducting ourselves the way they would want us to.
And because you mentioned former agents and people in the community, I mean, this has provoked some controversy within the ranks of current and former agents?
Not within the FBI. Again, who knows what people don't tell the director, but I should have asked Mr. Gohmert. If there are agents of the FBI who are concerned or confused about this, please contact me. We'll get you the transparency you need to see that your brothers and sisters did this the way you would want them to.
All right, I'm out of time, but I will say just when I was in the military, you had said no one would be prosecuted. I mean, maybe that was just for civilian, but I can tell you that people, if you had compromised top secret information, there would have been a court-martial in your future, and I yield back.
Would the director care to respond to that?
No, fine.
It's a direct comparison to the finding of yourself that, as you stated in your news conference, that no prosecutor would prosecute somebody under similar circumstances.
I understood Mr. DeSantis to be expressing a personal opinion. I accept that at face value. I just haven't seen the cases that show me on the public record that that's true. But I accept his good faith.
The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Director, did you make the decision not to recommend criminal charges relating to classified information before or after Hillary Clinton was interviewed by the FBI on July the 2nd?
After.
Okay, then I'm going to need your help in trying to understand how that's possible. I think there's a lot of prosecutors or former prosecutors that are shaking our heads in how that could be the case, because if there was ever any real possibility that Hillary Clinton might be charged for something that she admitted to on July the 2nd, why would two of the central witnesses in a potential prosecution against her be allowed to sit in the same room to hear the testimony? Now, I've heard your earlier answers today. You said that, well, it was because the interview was voluntary and they were her lawyers. But I think you're skirting the real issue there, Director. First of all, the fact that it was voluntary, it didn't have to be, right? You could have impaneled an investigative grand jury. She could have been subpoenaed. And I know you've said that you can't comment on that, and I don't really care about the decision about whether or not there should have been a grand jury here. But since you didn't have one, it goes to the issue at hand about whether or not this interview should have ever taken place. With due respect to the answers that you've given, the FBI and the Department of Justice absolutely control whether or not an interview is going to take place with other witnesses in the room, because the simple truth is, if, under the circumstances as you've described, those interviews never take place. If there was ever any possibility that something Hillary Clinton might have said on July 2nd could have possibly resulted in criminal charges that might possibly resulted in a trial against her relating to this classified information, well then, to use your words, Director, I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that. So, to me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails, correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails, correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. It's a low-level guy, and you're trying to move up in the chain, you might think about it differently.
Well, He lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
Oh, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Combetta?
Combetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay, well, my time's expired, but I have one last question, and I think it's important. At this point, based on everything, do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken? Yeah. I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department and my colleague, Mr. Gowdy here, notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with bleach bits, so the FBI didn't review that. After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with bleach bit, so the FBI didn't review that. And also after the subpoena, backups of the Platte River server were manually deleted. Now, Director, hopefully that list is substantially accurate because it comes from your own documents. My question to you is this: any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice, and to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton. And with that, I yield back.
Director, do you care to respond?
Very briefly, to ignore that which we don't have, we're in a fact-based world, so we make evaluations based on the evidence we're able to gather using the tools that we have. So it's hard for me to react to these things that you don't have. So that's my reaction to it.
The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you very much. Director Comey, thank you for being here. I know this is, there are a lot of things you would probably much rather be doing than sitting on the hot seat, so to speak. And here's where I'm coming from on this. You've been asked a lot of questions today about the Clinton investigation. And what I'm hearing from folks back in Texas, and I'm just going to take a big picture view of this, is this stuff just simply doesn't pass the smell test on a lot of areas. You just had my colleague from Texas, Mr. Ratcliffe, list a long list of things that y'all didn't have in the investigation. You've been asked earlier today, well, you know, would you reopen the investigation? What would it take to get you to reopen the investigation? We've had 5 people given immunity, which basically we got nothing when, you know, perhaps a plea agreement or something else might have worked. You have your interpretation in your previous testimony before Congress that Section 793F required intent when, in fact, the standard is gross negligence. And it is just a long list of things that just have people scratching their heads going, if this were to happen to me, I would be in a world of hurt, probably in jail. And how do you respond to people who are saying that this is not how an average American would be treated? This is only how Hillary Clinton would be treated.
Yeah, look, I've heard that a lot, and my response is, demand, when people tell you that others have been treated differently, demand from a trustworthy source the details of those cases. Because I'm a very aggressive investigator, I was a very aggressive prosecutor. I have gone back through 40 years of cases, and I'm telling you, under oath, that to prosecute on these facts would be a double standard, because Jane and Joe Smith would not be prosecuted on these facts. Now, you'd be in trouble. That's the other thing I've had to explain to the FBI workforce. You use an unclassified email system to do our business, and in the course of doing our business, talk about classified topics, you will be in big trouble at the FBI. I'm highly confident of that. I'm also highly confident, in fact certain, you would not be prosecuted. That's what folks tend to lump together. So I care deeply about what people think about the justice system, and that it not have two standards. It does not, and this demonstrates
But you look at General Petraeus in his handling of classified information. You look at, and I'll go back to what you're saying.
But when you look at it, demand to know the facts. I don't want to dump on General Petraeus, because the case is over, but I would be happy to go through how very different that circumstance is than this circumstance.
And you talk about, you tell your FBI agents, if you do what we're investigating here with material from the FBI, you'd be a world of trouble. I would assume that could potentially be fired. Is Hillary Clinton she didn't get in any trouble at the State Department. The only trouble she's got now is trying to explain it to the American people.
Right, she's not a government employee, so the normal range of discipline that would be applied to FBI employees if they did something similar doesn't apply. And I think that's some of the reason for people's confusion, lumping these two together, and their frustration, but it is what it is. And all I can tell people is, demand the facts. When people tell you, oh, so-and-so has been treated differently, demand the facts on that.
All right, so if somebody were to, let's just do a hypothetical. Let's say somebody here in Congress were to email my personal email some classified information, and I get my phone, it comes to my cell phone too, my personal email comes to my personal cell phone. I look at it and go, wow, that probably shouldn't be on there, and don't do anything. I mean, to me, that's being grossly negligent with classified information. And that's a violation of 793F. And that's exactly what Hillary Clinton did, I think. I mean, at what point do you get to intent? The classified information was on an unsecure server, you knew it was there, and you didn't do anything about it. To me, that's gross negligence, period. I would think I would be prosecuted for that.
Yeah, I'm confident that you wouldn't, but we just have to agree to disagree.
All right, if I ever get in trouble, I'm going to save this clip.
Don't do it. Well, I guess I can't control Congress. If you work for us, don't do it.
No, I have absolutely no intention of doing it. So again, I just want to say, don't get frustrated when we continue to ask these questions, because we're not badgering you because we want to badger you. We are talking to you because the American people are upset about this and don't think it was handled appropriately, and that's the basis, at least, of my questioning, and I thank you for appearing here.
And I totally understand that. That I think there are lots of questions people have, which is why I've worked so hard to try and be transparent. There's never been this kind of transparency in a criminal case, ever, but because I understand the questions and the importance of it, I've tried. But I hope people will separate two things: questions about facts and judgment from questions and accusations about integrity. As I said before, you can call us wrong, you can call me a fool, you cannot call us weasels, okay? That is just not fair, and I hope we haven't gotten to a place in American public life where everything has to be torn down on an integrity basis just to disagree. You can disagree with this. There is just not a fair basis for saying that we did it in any way that wasn't honest and independent. That's when I get a little worked up, sorry.
I'm out of time.
The chair recognizes the gentleman from Michigan, Mr. Bishop, for 5 minutes.
Thank you, Director Comey. I appreciate your testimony here today. Just in follow-up to all this discussion regarding the Clinton investigation, specifically with regard to the interview of Secretary Clinton, I'm holding in my hand a memorandum from Deputy Attorney General James Cole. It's dated May 12, 2014. This memorandum was issued to you and others on the policy concerning electronic recording of statements. Are you familiar with this memorandum?
Mm-hmm.
The policy establishes a presumption that the FBI will electronically record statements made by individuals in their custody. Now, I know that Secretary Clinton was not technically in custody, but the policy also encourages agents and prosecutors to consider electronic recording in investigative or other circumstances where that presumption does not exist. The policy also encourages agents and prosecutors to consult with each other in such circumstances. And given the magnitude of what we've been talking about today and the huge public interest and demand for information with regard to the public trust, I think this is specifically important to this discussion. Now, you're aware of this policy, correct?
Right, that applies to people that are in handcuffs.
But not, it also applies to, the policy also encourages agents and prosecutors to consider electronic recording in investigative matter and other matters where that presumption does not exist. Does it
Sure.
not?
The FBI doesn't do it, but sure, I understand that they encouraged us to talk about it.
So did the agents then did not consider to conduct the interview in a recorded situation then?
We do not record non-custodial interviews.
Okay.
Now, maybe someday folks will urge us to change that policy, but we don't, and we sure wouldn't want to change it in one particular case.
Well, that's the policy. I'm just reading the policy that's issued by the Deputy Attorney General, James Cole, that is to you and to others in the Department of Justice that establishes the policy. So if you don't do it, I assume that you're doing it against the policy of the Department of Justice.
No, that policy only governs custodial interrogation, so people who've been locked up. We do not, and it is not inconsistent with Department of Justice policy, record non-custodial, so that is voluntary interviews where someone's not in our custody.
Well, I'm reading this differently then, because it does say that there's an exception that it is within your discretion to record such.
Well, sure, you could, and I don't know, maybe some other federal investigative agencies do. The FBI's practice is we do not record non-custodial interviews.
Okay, thank you, Director. I want to pivot, if I can, and build off Representative DeSantis's questions with regard to the refugees attempting to enter the United States, and specifically with regard to Syrian refugees. Wondering if you can tell me, we've talked about this process and the fact that we do not have a process in place that we can rely upon. You've indicated before when you testified, and I asked the question, that we just simply don't have enough information to ensure that we have the information that we need to ensure that these people are not a threat to our country. Can you expand upon that now after a year? Can you tell me whether or not we've got more information, more capabilities to vet these refugees? And I say this because in my district in Michigan, in this fiscal year, Michigan has taken the fourth most refugees of all states, 4,178, and we've taken the third most for Iraq, the second most from Syria. Michigan has absorbed an enormous number of refugees, and I think you can understand our concern with regard to the fact that we don't have information necessary to identify whether or not they're a threat. Can you assuage my concern, the concerns of my constituents, that we have a system in place that we can vet these individuals and they don't pose a threat to our country?
I can assuage in part and restate my concern in part. Our process inside the United States government has gotten much better at making sure we touch all possible sources of information about a refugee. The interview process has gotten more robust, so we've gotten our act together in that respect. The challenge remains, especially with respect to folks coming from Syria. We're unlikely to have anything in our holdings. That is, with people coming from Iraq, the United States government was there for a very long period of time. We had biometrics, we had source information. We're unlikely to have that kind of picture about someone coming from Syria, and that's the piece I just wanted folks to be aware of.
Has anything changed in your vetting process? Have you updated it? Do you have any concerns with regard? We've seen an increased terrorist activity in the last 6 months, including New York, New Jersey, and Minneapolis. Has anything changed in the vetting process? Can you be confident that foreign fighters or other refugees entering the country are not planning future attacks on our country?
Well, as I said, over the last year, since I was last before you, the vetting process has gotten more effective in the ways I described. I'm in a business where I can't ever say that there's no risk associated with someone, so we wake up every day in the FBI worrying about who might have gotten through in any form or fashion to the United States or who might be getting inspired while they're here, so I can't ever give a blanket assurance.
Director, I respect your opinion, and this is not a policy question. I'm asking you based on your personal opinion as a law enforcement officer that we rely upon to keep this country safe. Is there anything that you would do to ensure, as you said, that our country is safe with regard to this refugee process?
Anything that I would do?
Anything that you do. Any recommendations you have for Congress, for this country, that would ensure our safety?
Yeah, I shy away from assurances of safety, given the nature of the threats we face. I do think that there may be opportunities to do more in the social media space with refugees in particular, and I talked to Jay Johnson yesterday about it. I know there's a work in progress. So much of people's lives, even if we don't have it in our holdings, may be in digital dust that they've left in different places. Are we harvesting that dust on people who want to come into this country in the best way? And I think there may be ground for improvement there.
Thank you, Director. And I will yield back. But, Mr. Chairman, I'd ask unanimous consent to enter the memorandum that I referenced earlier from dated May 12, 2014, into the record.
Without objection, it will be made a part of the record. The chair recognizes the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I appreciate you being here. You are, I believe, forthright, much more so than you said is in any criminal case we've had. But I'm also still in the military. I'm still in the Air Force Reserve. I went to my drill back in July. I was hit by an amazing amount of questions from different service members on this issue of how does the former Secretary of State get to do this, and yet we have members of the military who are prosecuted all the time. Your statements earlier were fairly startling when you said, I don't know of anybody else that's been classified as this. Just since 2009, the Department of Justice prosecuted at least 7 people under the Espionage Act, all for very similar cases. Now, you said go look at the facts. Well, we're looking at the facts in these cases. The interesting one, and you know, you said that in looking back at your investigation, mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All right. Well, it didn't take nothing but a simple legal search to find a Marine that fallen. Now, I guess their name is not Jane or Joe, so they did get prosecuted, okay? And this is the issue under 18 U.S.C. 793F, gross negligence. This is what the Marine did. They took classified information that was put into a gym bag, cleaned out, washed, and took. All right, simple mishandling. Court of Appeals actually upheld this case, and this is what they said, that the purpose of federal espionage statutes is to protect classified documents from unauthorized procedures, such as removal from proper place of custody, which would mean how you deal with this. Regardless of means of removal, it was apparent gross negligence and was approximate cause of the document's removal. It is, and they quoted United States v. McGinnis, said, it is clear the Congress's intent to create a hierarchy of offenses against national security ranging from classic spying to merely losing classified materials through gross negligence or the mishandling of. It was sort of also ironic for me that when I had to go back in July in this past month when I went back, I had to do my annual information assurance training that went through everything that we have to do with handling classified information. I have been in a war zone. I've been in this is just common knowledge among most everybody in the world, obviously not to the Secretary. How can you then explain to me this Marine's mistake in taking classified documents or mishandling them is more severe than the Secretary of State who sent and received classified emails on a regular basis, including those that were originally classified, not those that were classified later, but were originally classified?
Yeah, first of all, I'm familiar with the case, and I'm quite certain it's not a 793F case. It was prosecuted
His
as
conviction was under 793F.
Yeah, I don't think, I mean, I'll go back and check again. I'd urge you to, too. I'm pretty sure it's not under the gross negligence prong of 793F. But it's a Uniform Court of Military Justice prosecution, not by the Department of Justice. Am I remembering correctly?
This was from and is appealed out in the U.S. the Court of Appeals for the Armed Forces did actually hold it under this. Yes.
But regardless, I think even, I don't think this is under the same provision, but even there, that's a case involving someone who actually stole classified information, hard copies. What people need to remember, and I don't say this to make a little of it, I think it's a very serious matter. What happened here is The secretary used an unclassified email system, her personal system, to conduct her business.
And let's just stop right there. That in and of itself, and I understand it's Dr. Cummings, we've been through, you've been through a lot of questions, I apologize. But let's just come back to the basics here. We're trying to parse that I didn't have such a Sandy Berger or all these others who've been prosecuted, they took a hard copy. In today's society, and even understanding if you go through any information assurance class, anything else, they tell you it cannot be on a personal laptop. In fact, there was another chief petty officer who had classified information on a personal computer. It went back and forth to war zone. That is not physical documents. It's on a, to parse words like that is why the American people are fed up. They're fed up with the IRS commissioner when he does it. They're fed up here. I'm not attacking I think you're one of the more upright people I've met. I think you just blew it. I think the Attorney General blew it. I shared this with her. And I think when we come to this thing, there's no other way that you can say that there's no others that resemble this. As a lawyer, you're taught all the time to take facts and put them, they may not be exact, but they fit under the law. You can't, I mean, so I guess maybe I'm going to change the question because we're going to go down to a dead end. You're going to say it wasn't.
Can I
But let me
respond?
ask you this. I want to change questions. Do you honestly believe that a lady, a woman of vast intelligence, who is the First Lady of the United States, who is a senator, who had access to classified information, all the members here do, who is Secretary of State, who had even further classification ability, even beyond what we have here. Do you believe that in this case, honestly, she was not grossly negligent or criminal in her acts?
First of all, I don't believe anyone other than my wife. My question is, what evidence do I have to establish that state of mind? And I don't believe I have evidence to establish it beyond a reasonable doubt.
Then really what we're saying here is this. Is she is, and this is in essence what you're saying. You said, I can't prove it, and I understand. There's a lot of folks out there in the law that, they come to us all the time. I'm an attorney as well, and they come to us and say, it's not what we know, it's not what we think, it's what we can prove. I get it. But here's the problem with this, and this is the person who's asking to lead this country. If she can hide behind this and gleefully get approval from the FBI through an investigation, which has been covered here thoroughly, then I just do not understand. She is either the most arrogant, which probably so, or the most insanely naive person we've ever met. Because when I actually show evidences of basically the same thing, which you can take facts and correlate to law, this is why the armed forces right now have the new term called the Clinton defense. I didn't know. I didn't mean to. It's on my brain. It's the Clinton defense. With questions like this, Director, we have give the ability now to where nobody takes this seriously. And this is why people are upset. When it was originally classified, she can tell all the stories she wants. She can have the backup from you that no prosecutor, which is, again, amazing to me, that a law enforcement would tell the prosecutor, because how many times I've been on both sides of this, where the law enforcement agent said, I'm not sure we have a case here, but when the prosecutor looks at it, the prosecutor says, yeah, there's a case here. I don't really, frankly, no offense, care what, if I'm prosecuting, what the law enforcement officer, if I can see the case and I can make it, that's my job, not yours. And yet now we have a whole system that has been turned upside down, not because I don't believe your honesty of your people, but I believe you blew it because you, frankly, didn't have the whole situation into effect where the FBI would look political. And unfortunately, that's all you've become in this. And it's a sad thing because y'all do great work. You have do great work, and you will do great work. But I think it's time to start, we just bring down the curtain. There's a wizard behind the thing, this Hillary Clinton, who is playing all of us because she's not that naive. She's not stupid. She knew what she was doing because she was simply too bored. If she, God forbid, gets into 1600 Pennsylvania Avenue and just gets bored with the process, then God help us all. Mr. Chairman, I yield back.
Mr. Chairman, there's only two.
The Director is permitted to respond.
Yeah.
Two pieces of that I need to respond to. First, you said hiding behind something. This case was investigated by a group of professionals. So if I blew it, they blew it too. Career FBI agents, the very best we have were put on this case, and career analysts. We are a team. No one hid behind anything. American citizens should insist that we bring criminal charges if we're able to investigate and produce evidence beyond reasonable doubt to charge somebody. That should be true whether you're investigating me or you or Joe Smith on the street. That's the way this case was done. It's about evidence. And the rest of it I'll let go.
Mr. Chairman, I will, and I apologize if you're asking just to comment. I'm not, this is the problem, though. When you take it as a whole, it's been said up here, this is a unique case. You've talked about it being a unique case. Director, this is a unique case because I truly, and I don't think you convinced hardly anybody except your own group, I don't think you ever said they couldn't blow it. They blew it. Anybody else would have been prosecuted under this. In my humble opinion,
You're just wrong.
you say
You're just
no.
wrong. We'll just have to agree to disagree.
Well, unfortunately, there's a lot to disagree on this. Thank you, Mr. Chairman.
Time of the gentleman has expired. The gentleman from Idaho, Mr. Labrador, is recognized for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I've always appreciated your testimony before this committee, and I respect the work that you do for the FBI. When you made your recommendations to the Department of Justice to not prosecute Hillary Clinton, I actually disagreed with your decision, but I appreciated your candor in explaining to the American people and to us those recommendations. Since that decision, I continue to view you as honorable and a strong leader for the critical federal agency. In fact, I did 20 town hall meetings over the recess, and I was lambasted at every one of them. In fact, I think I lost votes because I defended your integrity at every one of those town hall meetings. And I told them why, even though I disagreed with your conclusions, I thought you came to it from an honorable place. However, as more information has come to light, I question the thoroughness, and I'm not questioning your integrity, but the thoroughness and the scope of the FBI's investigation. In the past week, we have learned of the grants of immunity to several key witnesses in the Clinton investigation, including Hillary Clinton's former chief of staff and one of the individuals responsible for setting up her server. I'm really disappointed by this revelation and confused as to why these immunity grants were necessary and appropriate given the circumstances. It appears to me that the FBI was very early in this investigation too willing to strike deals and ensure that top officials could never be prosecuted for their role in what we now know was a massive breach of national security protocol. We have a duty to ensure that our FBI is still in the business of investigating criminal activity. So at what point in the investigation was Cheryl Mills offered immunity?
Cheryl Mills was never offered immunity, not to quibble, but she was given letter immunity to govern.
At what point?
June of 2016, so June of this year, so about 11 months into the investigation.
So to be clear, was she offered immunity for interview and potential testimony or for turning over the laptop as evidence?
Turning over the laptop as evidence, it governed what could be done in terms of using it against her, that laptop.
To your knowledge, was Cheryl Mills an uncooperative witness prior to the immunity deal?
I think our assessment was she was cooperative. I forget the month she was interviewed, but she was interviewed fully before that.
And she always cooperated?
I think our assessment was, again, this is the odd way I look at the world, we had no reason to believe she was being uncooperative.
So could this investigation have been completed without these grants of immunity in place?
In my view, it couldn't be concluded professionally without doing our best to figure out what was on those laptops. So getting the laptops was very important to me and to the investigative team.
So in your vast experience as an investigator, as a DOJ attorney, now as an FBI director, how many times have you allowed a person who is a material witness to a crime you're investigating to act as the lawyer in that same investigation?
Well, to let is what I'm stumbling on. The FBI has no power to stop someone in a voluntary interview.
You're speaking, let's just be honest. You allowed, the FBI allowed Cheryl Mills to act as the attorney in a case that she was a material witness. How many times have you done that?
In the same sense that I'm allowing you to question me.
How many times have you done that?
I can't stop you from questioning me.
How many times have you done that prior?
I have not had an experience where the subject of the interview was represented by a lawyer who was also a witness in the investigation.
Okay, so you have never had that experience?
Not in my experience.
You prosecuted terrorists and mobsters, right?
Correct.
And during your time in justice, how many times did you allow a lawyer who was a material witness to the case that you were prosecuting to also act as the subject of, as the attorney to the subject of that investigation?
Yeah, as I said, I don't think I've encountered this situation where a witness, a lawyer for the subject of the investigation was also a witness of the investigation.
So this was highly unusual to have?
In my experience, yes.
Okay. In your answer to Chairman Chaffetz, you indicated that you had no reason to disbelieve Paul Gambetta when he told you that he erased a hard drive on his own. Is that correct?
Correct.
However, in the exchange on Reddit, He said, I need to strip out a VIP's email address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Those two statements are not consistent. How can you say that he was truthful when he told you nobody told him to act this way, but yet you saw this Reddit account that says where they told him that he needed to act in this way?
I think the assessment of the investigative team is those are about two different subjects. One is a year before, in the summer of 2014, about how to produce emails and whether there's a way to remove or mask the actual email address, the HRC, whatever it is, .com. And the other is about actually deleting the content of those emails sitting on the server.
It seems like in your investigation, you found time after time evidence of destruction, evidence of breaking iPhones and other phones, all these different things, but yet you find that there's no evidence of intent. And I'm a little bit confused as to your interpretation of 18 U.S.C. 793F. On the one hand, you've said that Secretary Clinton couldn't be charged because her conduct was extremely careless, but not grossly negligent, correct?
That's not exactly what I said.
That's what you said today. But you've also said there was no evidence of her intent to harm the United States. So, but you'll agree that a person can act with gross negligence or even act knowingly without possessing some additional specific intent. So which is it? Is it a lack of gross negligence that she had or a lack of intent?
In terms of my overall judgment about whether the case was worthy of prosecution, it's the lack of evidence to meet what I understand to be the elements of the crime, one, and two, a consideration of what would be fair with respect to how other people have been treated. Those two things together tell me, and nothing has happened that's changed my view on this, that no reasonable prosecutor would bring such a case. The specific intent question, yes, I agree that specific intent to harm the United States is a different thing than a gross negligence or willfulness.
So just one last question. You talked about Mary and Joe. And Mary and Joe would be disciplined at the FBI if they did what Hillary Clinton did. If Mary and Joe came to you and asked for a promotion immediately after being disciplined, would you give them that promotion?
Tough to answer that hypothetical. It would depend upon the nature of the conduct and what discipline had been imposed.
And what if they ever asked for a promotion that would give them management and control of cybersecurity of your agency and the secrets of your agency after they had done these things? Would you give them that promotion?
That's a question I don't want to answer.
All right.
The time of the gentleman has expired. The chair recognizes